the Outreach Manager at the National Women's Law Center. I'd like to thank you all for joining us for today's webinar, State Policy Solutions to the Need for Fair Scheduling. This is part of the Law Center's report and accompanying webinar series entitled Moving Women and Families Forward, a State Roadmap to Economic Justice. Building on the work already underway at the state level, the roadmap provides a vision of an integrated state legislative women's economic agenda. To find out more about the roadmap, please visit nwlc.org/roadmap. We have just a few housekeeping notes before we begin today's presentations. First, all lines will be on mute during the webinar. We will be taking questions after our experts are finished with the presentations, but we encourage you to submit questions throughout the webinar. You can do so by typing it into the designated area on your webinar toolbar and hitting send. Please note that we'll also be recording today's webinar, and you will receive a link to the recording of the presentation as well as a link to the PowerPoint slides within the next few days. Finally, please note that this webinar is intended for advocates and those interested in the subject and is not intended for press purposes. At this time, I'd like to turn the floor over to Liz Watson, Senior Counsel and Director of Workplace Justice at the National Women's Law Center. Liz, take it away.
Thank you, Amanda. We're very excited to be here today with you to discuss the growing movement for schedule fairness, which is a key part of a women's economic agenda in many states. Women make up 2/3 of low-wage workers and still shoulder the lion's share of caregiving responsibilities. Unpredictable schedules over which workers have little control have a huge impact on women and their families. So thank you so much for joining us and for all of the incredible work that many of you on the phone are doing in your states. We have many members of the National Scheduling Coalition on this call, and we hope that future webinars will present the opportunity to hear from you about your work. With 10 states introducing bills since 2014, we are all learning from each other in real time. On today's call, we will hear about the national landscape of this growing movement, why there is such a need for this legislation, and dig into some of the key policy questions that states have had to tackle. I'm excited to introduce the excellent speakers we have lined up for you today. Elizabeth Johnston from National Women's Law Center has been deeply involved in conceptualizing and drafting scheduling legislation, and this is part of a broader body of work in which she has played an integral part, working with workers' organizations on improving working conditions in low-wage jobs. Jenya Cassidy is Project Director with the California Work and Family Coalition, which is a project of Next Generation. Jenya worked tirelessly on the successful effort to pass the San Francisco Retail Workers' Bill of Rights, which we'll hear more about today, and she's also involved with the effort to pass a statewide scheduling bill, which has been part of the California Women's Economic Agenda. Andrea Peluso is co-founder and executive director of Family Forward Oregon. Andrea's organization did a ton of work this year to have a successful introduction of her state scheduling bill, and we are very excited to hear more about that. Charlie Carter is the executive director of Maryland Working Families. Maryland Working Families is a grassroots independent organization that advocates for legislation to address the needs of Maryland's working families. Charlie was at the epicenter of the scheduling campaign in Maryland this year with Maryland Working Families, and this was included in the Women's Economic Agenda that Maryland Working Families helped to lift off the ground. Anna Haley Locke is Associate Professor and Associate Director of Undergraduate Programs at the University of Wisconsin-Madison School of Social Work. Anna has conducted extensive research on the impact of work hours insecurity on workers and their families, and she'll share some of her latest research with us today. She'll kick us off with an overview of why unpredictable schedules over which workers have little control are so tough for women and their families. And then Elizabeth will do a quick roundup of the exciting movement in the states this year on scheduling, followed by a discussion with Charlie, Andrea, and Jenya about the scheduling legislation in their states. So Anna, please kick us off.
Great. Hi, everyone. So I'm going to talk about work hour insecurity. A co-author of mine, Charlotte Alexander, and I have taken to using the term work hour insecurity to describe the result of a set of employer practices that a number of employment researchers have increasingly observed in our studies of low-wage, hourly jobs, predominantly in the service sector. As an overarching feature of work hour insecurity, employees lack control, or for that matter, even input over their work schedules. This is not to say that some employees don't seek reduced hours in some cases, or don't ever try to get accommodations to go home early or call off a shift, but the key is that many workers at the bottom of the U.S. labor market right now have limited or no say in their hours. So employers pair this with a set of practices that do three things. They don't give workers as many hours as they would like or believe that they would get at the point of hire. They vary their workers' hours, so from week to week, month to month, even day to day, the days and the hours of work change. And then finally, employees, oh, actually, let's go to the next slide. Pardon me. There we go. This is what I'm talking about. So lack of control, not enough hours, variable work hours, and then finally, employers make work hours unpredictable, so with workers not knowing in much, if any, advance when they will work. So getting your work schedule, the Sunday before the Monday start of the week. So in the context of limited control, you have these three dimensions that create work hour insecurity. What we know from the fairly limited data we have so far is that potentially at least a third or so of workers face this, and they tend to face more than one of these mechanisms together. So not just not enough hours, but they also face unpredictability or variability in that. Okay, next slide. Okay, so, pardon me. Okay, so the practices that employers use that create work hour insecurity have been termed just-in-time scheduling, which riffs off the decades-old approach to handling inventory to bring products to market only when they are needed in the precise amount that's needed, kind of like what Walmart has been famed for. Here, they do a range of things like offering no set schedule or very last-minute posting of schedules. They make last-minute shift changes, so they reduce hours, they cancel shifts, they add hours at the last minute. They may make workers be essentially on call, so you have to call in the morning of the day of work and find out if you're needed, if you have to come in, for how long, et cetera. And then they may get sent home unexpectedly early from their shift. This is all in a context of employers. The context of this is a prolonged bad labor market that favors employers, the decline of unionization and workers' voice in the workplace, and then the lack of laws to date, or laws that have been followed to regulate how employers schedule workers. Okay, next. I've been asked why employers engage in these practices, and there are several reasons that researchers have identified and that employers have noted themselves in popular media. So first off, it's having flexibility in staffing. So in a time of 24/7 operation of service sector firms, employers keep lots of workers on payroll who are hungry for hours, making it easier to plug in holes in schedules. There are also wage savings, so not paying for any worker time that's not absolutely necessary to sales. Avoiding OT, so the dread of many retail employer, which blows their very precise labor budgets and labor to sales ratios, and then avoiding triggering benefits eligibility. Okay, next slide. So what does work hour insecurity do? Well, it has a lot of different effects. We can think of at least three different constituencies. So workers themselves, their families, and their communities. So for workers, it affects eligibility for public assistance, ability to attend school, to increase skills and get up into the middle class or better jobs, to get and keep a second job. For families, as Julia Henley at the University of Chicago has examined, their effects on arranging dependent care during work hours, to budget and save as a family, to maintain family routines like dinner, homework time, quality time, and this all increases then work-family and within-family conflict. And then some of the work that I've done recently looks at community effect in the sense of this kind of schedule and security. It affects the ability for communities to have engaged, present members, whether it's religious institutions, community development, or organizing, and then in my case, school involvement, as I've studied. Okay, next slide. So real briefly, I'm going to talk in a couple of slides about a study I've recently done with Lynn Posey-Maddox, looking at, by interviewing mothers as well as surveying them, a sense of how their employment shaped their family engagement. Why the heck did we study this? Because in education reform initiatives, family-school engagement has been an increasing focus that schools are held accountable for, and this is going to be part of the ticket to getting schools better. So we wanted to know, gosh, how does employment affect that? Okay. Next slide. Okay, so we studied an occupationally diverse group, both professional workers and low-wage hourly workers. So in terms of professional workers, they did have access to time-related benefits and more autonomy or control to use those benefits. So Anna, a social worker up top, talks about schedule flexibility and paid time off that allowed her to engage and made it a lot easier. She was aware compared to other parents. But there were trade-offs. So in this case, lower pay in exchange for a schedule that was flexible or reduced hours, being shifted from salary to hourly pay, facing increased spillover of work into non-work or family or school engagement time, and then having to quote-unquote make up for the use of those benefits through just being expected to be a better, more accessible worker in general. Okay, next slide. Now let's go on to talking about hourly, low-wage workers. So they, of course, not surprising to us, they had a more limited, unpaid, often hard-to-use flexibility or time benefits, pardon me, which effectively became a substitute for more flexible schedules. So we had Joan talking about, I can't ever leave, like I have to be there 5 to 9. This is her second job in the evening to supplement the pay for her day job. Often the smallest usable unit was a full day. So they couldn't just cut out for 2 hours to go to a quick classroom thing at their children's schools. They were required to give advance notice, 1 to 2 weeks, when often the schools didn't give them that much notice for the events. They had to find their own coverage when they missed shifts. And then, of course, vacation or pay time, when they had it, was in competition with family time off, like caring for a sick kid or going on vacation, was in competition with taking time off to be engaged in school. I'm going to do a final slide now, so next slide, that talks about then the scheduling realities that we encountered. So for these same hourly service workers, so waiters and customer service representatives and other kinds of folks like this, they faced a lot of unpredictable schedules and very scarce hours. So the combination of that meant that when they got access to new shifts or additional hours, they had to jump on that for family financial stability rather than say, no, I plan to go to my son's concert. Mary talked about that her hours were often just a guesstimate. She didn't know when she had to work, so it was really hard for her to schedule going to events at her son's school. And because she was often sent home early from a shift, she just had to jump at whatever she could get hours-wise at work. And then they had little scheduling control. So even when they had the time off to go to a school event approved, at the last minute a supervisor might nix that because a coworker was sick, they had an influx of customers, this kind of thing. So combined with having difficulty with, depending upon public transportation, for example, they would be on buses all day long with minimal hours, trying to get to school events and having a really hard time of it. Okay, so I'm all done.
Thank you, Anna. Your work is a very important backdrop to understand the urgency of securing scheduling protections for workers. Now I'd like to turn to Elizabeth Johnston to give us the Cliff Notes version of what's been happening around the country on scheduling this past year and how we got here. Elizabeth?
Hi everyone, my name is Elizabeth Johnston and I'm really excited to be participating today. As Liz said, I'm going to give just a brief overview of scheduling legislation to date. Regulating worker schedules is not entirely new. You can go to the next slide, Amanda. Beginning in 1972, states began adopting reporting time pay laws. These laws were intended to curb the abusive practice of sending workers home without paying them for the hours in their scheduled shifts. When workers show up for work but are sent home early, the laws require employers to pay them for a minimum number of hours, between 2 and 4, depending on the state. This discourages those last-minute adjustments in staffing by canceling shifts after workers have already shown up or sending workers home early when business is slow. These laws have provided an important model for federal and state legislation. In addition to reporting time pay laws, the District of Columbia and California also require 1 hour of additional pay for employees working split shifts. Those are shifts of non-consecutive hours separated by more than a 1-hour meal period. Often workers, especially restaurant workers, will work 2 shifts in one day with a break of several hours in between. This break may not be long enough for the worker to go home or really to do much else besides wait around. Split shift laws provide some compensation for that time. Workers also report having few opportunities for meaningful input into the timing of the hours that they work, and many are unable to request even minor changes to their schedules without suffering a penalty. In response, in 2013, San Francisco and Vermont enacted right to request laws. These laws create a right for employees to make scheduling requests and protect them from retaliation. Such laws have been in place with great success in the United Kingdom, Australia, and New South Wales for years. At its outset, the UK law applied only to caregivers of very small children in response to concerns from the business community. Over the years, with little business opposition, the right to request has been expanded to all employees in the UK. In July of 2014, Representatives DeLauro and Miller and Senators Harkin and Warren introduced the Schedules at Work Act, which responds to workers' need for predictability, stability, and a say in their schedules. It provides a right for all employees to make scheduling requests free from retaliation. And those employees making the request due to caregiving responsibilities, a second job, their own serious health condition, or to pursue education or workforce training would be entitled to receive their scheduling request unless the employer has a bona fide business reason to deny it. And when any employee makes a scheduling request, the bill would require employers to engage in a good faith interactive process in considering the request. For those employees in certain jobs where abusive practices are especially well documented, restaurant, retail, and building cleaning, the bill would provide additional baseline protections. For those employees, it would require reporting time pay, split shift pay, additional pay for call-in shifts, and shift changed or canceled 24 hours or less in advance, and a requirement that the employers provide employees with at least 2 weeks advance notice. However, the employer would not be required to provide any additional pay during periods when the regular operations of that employer are suspended due to events beyond the employer's control. In addition, on the date of hire, the employer would be required to inform the employees of the minimum number of hours they could expect to work in each pay period. This bill will soon be reintroduced in this Congress. At the end of 2014, San Francisco introduced and subsequently enacted the Retail Worker Bill of Rights, which applies to formula retail establishments, those retail stores, fast food businesses, restaurants, hotels, and banks with at least 11 stores nationwide and at least 20 employees in San Francisco. The bill requires employers to post schedules 2 weeks in advance, to provide an extra hour of pay for schedule changes made with less than 7 days notice and more than 24 hours notice, and 4 additional hours of pay for schedule changes made with less than 24 hours notice. It also requires that on-call employees be paid for at least 4 hours, regardless of whether they are called in or how many hours they actually work. The bill provides also protections for part-time workers and prohibits discrimination against part-time employees with respect to rate of pay, ability to earn paid or unpaid time off, or access to promotion opportunities. It prohibits employers from requiring open availability and requires employers to offer any additional hours to existing qualified part-time staff before hiring any new employees. It's been very exciting to see the number of state advocates that have taken on this issue in the past year. Since 2014, 10 states have introduced bills to curb difficult scheduling practices. There are important variations between and among these bills, which we will discuss later today. That said, many contain the same general types of provisions, which I will briefly summarize. The first is advance notice. 8 of the 10 bills require employers to provide hourly workers with at least some advance notice of their schedules. The amount of notice ranges from 1 week to 3 weeks, and many require an additional hour of pay for any changes made after the schedule is posted, and 4 hours of additional pay for changes made with less than 24 hours notice. Others require additional pay only for those schedule changes occurring within 24 hours of the start of the shift. The bills vary in the extent to which they provide exceptions to the requirement to provide extra pay for late change schedules. And some of the bills prohibit an employer from requiring an employee to work a schedule change after the schedule is posted unless the employee consents. Our other panelists will explore these issues more in a moment. 7 bills include some version of the right to request. 4 of those bills specifically require employers to engage in a good faith interactive process with their employees and to notify the employee of its decision regarding the request. 3 bills include a right to receive a schedule change for those high priority employees, those that need the change due to caregiving responsibilities, education or workforce training, a second job, or the employee's own serious health condition. 2 of the bills permit employers to deny the request only if the employer has a bona fide business reason to do so. 7 bills respond to the rise of on-call shifts and require employers to pay on-call employees for a minimum number of hours, between 1 and 4, regardless of whether the employee is called in. Low-wage workers, who have the least say in their schedules, are also far more likely than the overall workforce to work part-time and voluntarily. Like San Francisco, Minnesota's bill prohibits employers from discriminating against part-time employees in terms of pay, eligibility for leave or time off, or eligibility for raises or promotions. Minnesota's bill also requires employers with additional hours of work available to first offer those hours to qualified current part-time employees before hiring new employees. At the same time, some workers struggle to get enough hours. For others, the work week is just too long. 3 bills protect employees from overwork by permitting them to refuse to work more than 6 consecutive days, more than 55 hours in a work week, or during hours that occur less than 11 hours after the end of a previous shift, or during the 11 hours immediately following the end of a shift that spanned 2 days. If an employee works in the aforementioned conditions, the employer would be required to pay the employee at the overtime rate. These are just some of the solutions states are exploring, solutions that are all so important to workers. When workers have schedules at work, everyone wins, and these bills are the critical first steps toward creating workplace policies that truly work for workers and their families.
Thank you, Elizabeth, for that excellent summary of the state of play. And now we're going to dig in and hear about Maryland, Oregon, and California's scheduling bills in a conversation with Andrea, Charlie, and Jenya. And we'll save some time for your questions at the end. So first, let's do a lightning round, and it would be great to hear from Andrea, Charlie, and Jenya, and we'll go in that order, a little bit about what was contained in your bills, the current status of the bills, and who's in your state coalitions. And you each have 3 minutes. And Andrea, we're going to start with you. If you could advance the slide. Thank you, Amanda.
Great. Thank you so much for inviting me to be a part of the call today. This is such an important topic, and we're thrilled to be working on it with our partners at the National Women's Law Center. We have a small but growing coalition of organizations that work in sort of the economic justice realm who've been working on designing a scheduling bill together this year. Our bill, I'll lay out a few of the components which are spelled out in more detail in the slides that you have, does a couple of different things. So it's sort of looking at scheduling broadly. It requires that employers post schedules with 3 weeks advance notice. It establishes predictability pay, but with some exceptions. So 1 hour of additional pay for shifts that are changed within that 3 weeks to 24 hours before the shift begins. 4 hours of additional pay for shifts that are changed within 24 hours, 4 hours or the length of a shift if it's less than 4 hours in reporting pay for employees showing up to a shift if they're sent home early, 4 hours for on-call work. So if you're placed on call, you should be guaranteed at least 4 hours of pay for that time. We also established a right to request a predictable or flexible schedule that employers need to go through an interactive process that we outline to weigh the request for a flexible or predictable work schedule. And then in some cases, we established a right to receive the flexible or predictable work schedule. And in that case, an employer would have to meet a higher test of proving a bona fide business reason why they cannot meet that request for specific cases. And then generally we outlined in more detail sort of what the definition of a bona fide business reason and or interactive process would look like.
Thank you, Andrea. Please advance the slide. Charlie, let's go to you in Maryland.
Hi, thank you for inviting me to be part of this call. We're very excited about this in Maryland. It was our first year of introducing this bill. Again, as the slide outlines, it permits employees to make scheduling requests and compels employers to consider those requests unless they can prove that there's some reason they can't accommodate. It requires 21 days advance notice of schedules, and then provides for 1 hour of predictability pay for all the changes, any changes to that schedule that occur within that 20-day period between the time it's posted and 24 hours before the employee is supposed to work that schedule. And also provides for reporting pay. Maryland is one of the few states on the East Coast that doesn't have some form of reporting pay, meaning that if your shift is canceled or shortened, that employees are required to be compensated for a minimum of 4 hours. We had a very diverse coalition as part of this bill, and we had to make some considerations. The one was whether we wanted to include overwork and split shift protections in this Fair Scheduling Act, or whether we would try to do that separately in another bill. And in this first year, we did actually have a second bill that was called the Right to Rest Act that dealt with overwork and split shifts. We'll consider that in the next year when we bring this back next year, whether we will be able to make them one bill or continue on a track of whether we should continue to push them separately. We had a pretty broad coalition that were part of our allies pushing this, which included labor organizations, traditional women's organizations, children's advocacy and child welfare groups and nonprofits, the faith community. We also brought in health and mental health experts and the PTA and teachers associations. So we tried to attack it as a real health of the family and health and well-being of children, and that seems to be where we're making our greatest strides in pushing this, advancing this.
Thank you, Charlie. And let's please advance the slide, and Jenya, we'll turn to you.
Thank you. I really appreciate the opportunity to be here and talk about the California bill. I work with a statewide coalition, the California Work and Family Coalition, and we are a coalition of parents, caregivers, advocates, and unions who our focus is really having, workers having the right to put their family first. And this legislation, our California bill, is definitely a priority for our member organizations. It's led by UFCW, United Food and Commercial Workers, and the Western Center on Law and Poverty. And that's a really important connection around the bill because it's, the majority of women are doing this kind of work. They're the wage earners, and they're, UFCW organizes a lot of great women leaders. And also the bill, as you'll see here, it applies also to people who are on public assistance can take some time off under this bill to apply for public assistance and to do all of the different things you need to do when you qualify, which many retail workers do right now in our state. So the bill, AB 357, applies to large food and general retail establishment employers, and that's 500 or more employees in California and having 10 establishments around the country, the United States. It requires 2 weeks of advance notice of schedules, and there's additional pay for schedule changes, and these schedule changes are last minute and also employer schedule changes. And when those changes aren't, it also requires additional pay for the on-call shifts. So it says here that employers allow employees to be absent for work to attend appointments, and that's a very key part of this that we're really proud of. And I will talk a little bit more about some of the decisions that went into this, but this is basically what the bill is and does for California.
And Jenya and Charlie, these scheduling bills, I believe, have been part of your women's economic agendas in your states. And Charlie, could you talk about where this fit into your women's economic agenda briefly and what the other pieces of that agenda were and why you thought it was important to message this as an important women's issue? And then, Jenya, we'll turn to you.
Certainly. Well, as we mentioned, that these women overwhelmingly shoulder the responsibility for caregiving in the home, both for our parents and for our children. And although scheduling had been, the scheduling issue had been broached in our state before, previously it had always been talked about in view of as a labor issue. And we really wanted to highlight and really underscore the impact on families and particularly on women that non-standard scheduling has, and the insecurity that the instability that it has on the destabilizing effect that it has on all families or on families in general. And so we really felt it was strong. It was important to be part of an overall package that included pay equity and paid sick days, and as I mentioned previously, this mandatory overtime, which for some industries is a problem. We presented them all together and have been able to build a pretty strong coalition around it with non-standard partners. Working families, we traditionally partner with community groups and with labor organizations, and much less so with traditional women's advocacy organizations, and almost never with child welfare agencies or children's advocacy groups, nonprofits that tend to not want to push aggressive policies. But by showing the impact on children and really getting sound testimony on the impact on the mental health of women and children, we've been able to really underscore that this is not just a labor issue, that it really, the state has to take a look at it from a different perspective and act from that perspective.
Thank you, Charlie. And Jenya, let's hear from you on this as a piece of the women's economic agenda in California.
Yeah, I thought Charlie made some really interesting points about how this can sometimes bring in new and different partners who don't always look at labor rights as a children and family welfare issue. I mean welfare as in well-being, and I think that's really such a key thing. In California, we have this brand new network. It started just at the beginning of this year. It's the Women's Economic Agenda of California, called California Stronger Together. And it's a lot of different organizations, not just organizations that are focused primarily on women's issues, but it's definitely led by equal rights advocates and the women's policy initiatives. And they're really shows how this law fits in with a bigger picture of what is really important for women. Women in the state of California, like everyone else, are the caregivers, and they're also the wage earners. In a lot of families, they're the sole providers. So having unpredictable scheduling is forcing us to improvise constantly around our child care or family caregiver responsibilities, and also creates a lot of stress when you're not sure if you're going to have enough money to pay groceries. Because as we know, when schedules change, the same hours don't always stay in place, and people may work 10 hours one week, 30 hours the next, and they can't count on their paycheck the way they can when they have some predictability. This is a very key issue, and it helps fit in with the pillars of the Stronger Together. There are wages, the kind of wages that women make, and then there's work-family support, which this is one of the key pieces, and then there's childcare. And I think the importance of being part of that shows how it fits in with a bigger picture. And it's also important, this law definitely impacts men, which impacts families, and we look at sort of the whole family, but it's been great to be part of this women's economic agenda to really talk about how this disproportionately affects women in our state.
Thank you, Jenya and Charlie. Now we're going to take a moment to talk about some of the key decision points, please advance the slide, that you all have encountered in your states and that others on the phone in their states have encountered in drafting these bills. And your comments are a great segue to that because one of the key questions in drafting these bills has been how to ensure that workers have both more schedule control and greater predictability and stability in their schedule. Please advance the slide. So, for example, many of the state bills require 3 weeks notice of schedules and include provisions saying that the employer cannot require anyone to work a schedule changed after the schedule is posted at 3 weeks. And that's the case in Maryland and Oregon. And I included this slide here, if you look at the chart on your screen, to try to help people see similarities and differences among these bills, because as Elizabeth explained, they have many things in common but take differing approaches to certain questions. So many of these bills also require employers to provide extra pay for any schedule or for most schedule changes after the 3-week schedule is posted. And with some limited exceptions, that's the case in Maryland and in Oregon. One of the concerns that some advocates have had is how this affects employees' ability to initiate schedule changes. So, for example, Elizabeth and I have been talking to workers in low-wage jobs in different parts of the country about their schedules and how they affect their family responsibilities. And we recently heard from a McDonald's worker in Chicago that when she was asked to be taken off the schedule because she was at the hospital with her son who'd broken his leg, she was written up and her hours were cut for months afterward. Another worker called out because she couldn't leave her children at their child care center because when she showed up at 6:15 in the morning to drop her kids off, the center was closed due to snow. It was a Monday morning and they hadn't notified anybody. She was written up. Many employers seem to penalize workers for making changes to the posted schedule already. So you can see the variations on this slide in the way that states have approached predictability pay. California, for example, has had predictability pay kick in 1 week before the employee is scheduled to work, although they're requiring 2 weeks advance notice. And Oregon and Maryland have had it kick in immediately after the schedule is posted 3 weeks out. Next slide. So by requiring an employer to pay extra to an employee who is called in to cover a shift for another employee who calls out, and saying that no employee can be required to work in place of someone who calls out unless that person consents, some of us have been concerned that some of these bills may inadvertently tip the scales toward employers being even less likely to grant employees' requests for schedule changes, and they're already very unlikely to do that and, in fact, penalizing employees for making changes. And others have felt that the need to stop employers from making changes to the posted schedule is the paramount concern that we need to address. Another concern that has been raised is how the predictability pay provisions may limit employees' ability to get more hours, since, as Elizabeth mentioned, involuntary part-time work is a very significant problem for workers in low-wage jobs in particular. So you can see, oh, I'm sorry, could we advance to the next slide? Thank you. So you can see on this slide that California's bill provides exceptions to the predictability pay requirement when the reason that the employer needs to make a change is that another worker has called out, which would seem to potentially help address the unintended consequences of deterring employers from offering sick days and other forms of time off. But there are many differing viewpoints on this, and I think we'll have a chance to discuss some of those on this call. I'd encourage you, I'm not going to read you the slide that's in front of you, the exceptions to the predictability pay requirements, but it's a helpful cheat sheet on the way that 3 different states have tackled this issue. Please advance to the next slide. As you can see from this slide, another key difference between California's bill on the one hand and Oregon and Maryland's bills on the other is that the California bill does not have the consent requirement, and it states that if the reason an employer needs to change a shift is that another employee has called out, the employer doesn't have to pay predictability pay. So in this way, it seems to thread the needle between requiring employers to provide predictability and ensuring some level of control. And this is just how California has chosen to do it. And so, Jenya, I think we would be interested in hearing from you your thoughts on how that balance was struck in the California bill, and then we'll turn and hear from Andrea on how a different balance was struck in Oregon. So, Jenya, would you like to speak to that?
Yeah, I think this is really interesting, and I'm really looking forward to hearing how this has happened in other states. I think one of the situations that we face in California is that we have, well, we have Democrats and we also have a lot of great work-family law. You know, there's a couple of things that does. A lot of our Democrats are really moderate, and the business lobby in California is incredibly strong, and it takes a lot of work to sometimes educate businesses meaning the business lobby, not necessarily individual businesses, about how these types of laws really have a positive impact on everybody and have a positive impact on employers. We know some model employers in California that really do this well, and it's sort of a process. So it's sometimes things like, having consent, where in California we don't have a consent requirement for employees. Some of those things, it's kind of a process whereby this law is very new. It affects really large employers that can definitely do this. And there's even been a process here of really working with the employers to some extent to make sure that there aren't some of those unintended consequences. And, it's kind of, that's sort of the best answer. The other piece is, in California, this law takes place in the context of having some other work-family rights. So we're always working in that context where, sometimes another law gives you the right to do something that this particular law doesn't address. So for us, it's a process of both educating, workers and members of the coalition on how this law, interacts with other laws, and also really working, I think, a long game with employers on, showing that this law is actually going to be really beneficial for both employees and employers. So it's just kind of a process with the business lobby right now.
Eugenia. And Andrea, would you like to talk a little bit about how you struck the balance between these issues of predictability and control and the requirements in your bill that no employee may be required to work a schedule changed unless that employee consents once the schedule is posted, and the requirement to provide the predictability pay after 3 weeks?
Yeah, so we had a lot of conversations about this, and we absolutely understand that these kinds of bills are walking a really fine line between an employee's own need for predictability and their own need for flexibility, and also one employee's need for predictability and another employee's need potentially for flexibility. And that, there are often cases where a schedule will be posted and the change that originates isn't because of the employer's need, but because of another employee's need, or maybe the employee's own need. And so we wanted to really be cognizant of that and design some ways in which we could kind of walk that line a little bit. And I feel like we've struck elements. I mean, we're learning as we go along with the process of introducing this bill and hearing feedback about it, more about sort of what might work better in different types of employment settings. But, in the end, we kind of landed on we require advance notice of schedules. Folks have to have their schedules 3 weeks in advance according to what this bill says. And we didn't feel like it made a lot of sense to have an advance notice requirement without any penalty associated with it. We can make the request that folks give a schedule, but without any sort of accompanying penalty. We weren't really sure there was much meat to that request. So we went where we said there's an advanced scheduling requirement, we said there is a penalty for not posting. And took that all the way from 3 weeks to 24 hours, that 1 hour of additional predictability pay. Some, I think, could argue that decreases an employer's desire to honor flexibility requests from 3 weeks to that 24 hours by other employees or by that employee if they think that they are going to be out an extra hour. We did include some ways in which that the employer would not be on the hook for that extra hour of pay, including that the employee requests the change, or that it's a request by another employee, or it's to use sick time or vacation leave or other things that are maybe required or soon to be required in Oregon under state law. So we tried to kind of walk that balancing. In almost all cases you have to offer predictability pay, except these few places where we think it's really about the employee's own request.
Thanks, Andrea. That's very helpful. And I think what's really interesting here is you see two very different approaches to dealing with this question of balancing predictability and control, coming out two very different ways. So, for example, California has this, those of you who haven't checked it out yet should check it out, has a wonderful website called www.schedulefairness.com about their bill. And, on this very question, what if an employee cancels and another worker is asked to step in? Does the employer still have to pay for a change that is out of the employer's power? That's in their FAQ. And their answer is, and this is the website from the State Advocates supporting this bill know we understand that if one worker is asked to cover for another worker, that it's out of the employer's control, and these situations are exempt from the pay requirements listed above. So really interesting. It's an interesting question how to tackle that, and a very diverse approach is being taken in the state. I think it would be great to hear a little bit about from you about the opposition that's been raised in some of your hearings, if there were surprises that you weren't expecting that you got in terms of opposition testimony, and if there are things you think you might do differently next year given what you've learned. And Charlie, why don't we start with you?
Certainly. I think we were expecting there to be opposition from the Chamber of Commerce and probably the Retail Association. I think where we were a little bit not expecting as much pushback was from staffing agencies and temporary agencies who actually turned out in force against to testify against the Fair Scheduling Act in Maryland, and with some effectiveness, some degree of effectiveness, and it will certainly force us to go back and look again at the law and figure out what will need to change to either in explaining in our definition of who an employee is, or in just how we deal with at-will or contract employees that work for staffing agencies. The other area where we got a significant amount of pushback that we didn't expect was from the Association of Builders and Contractors, the construction industry. They, made a very strong arguments about needing to work when the weather was good, and when the weather wasn't good, the flexibility that they demanded to be able to use the optimal weather conditions to do especially outdoor construction. So those were two areas where two industries where we found we were not expecting the kind of pushback that we got, and they made very effective cases, and we'll be working with them over the summer to figure out how we can address their concerns, but still get the meat of the bill through.
Thanks, Charlie. Andrea, would you speak a little bit to the opposition that you heard and tricky issues, things you want to do differently next year?
Yeah, we approached the hearing that we had as an informational sort of hearing, knowing that we needed to air a lot of the concerns that employers had, and I think the next steps for us will be moving to an outside the legislative session work group between some of our advocacy organizations and some of the employer groups who testified, so we can further hone and sort of strike the right balance on all of these issues. But I can say, fundamentally we heard from a lot of employer groups and individual employers who really believe that the employer should have the maximum amount of ability to schedule folks however they feel like they need to. And they were very resistant to the idea that, that they should have to do anything other than have folks there when they needed them there and tell them not to come if they don't need them there. And there was, I think, a degree of, if people don't like the way it works in our work setting where we require you to be available on a moment's notice, they can go find another job. And I think part of the thing that we all struggle with as advocates is helping more folks to understand that, most of the work that low-wage workers have access to at this point operate in this way. So there isn't some other job where, potentially you have access to the degree of scheduling control that you need. And I think that was an interesting thing. And then the degree to which, employers would say, I should have a right to send folks home if it's not busy without pay, or call them in at a moment's notice if I need to. And I do think, again, we need to walk that line between where it is an employee's request for flexibility or predictability, and where it's really just an employer sort of refusing to change their practices.
And Andrea, I think that's a good point to pause for a minute on a provision of your bill that looked fairly different from California and Maryland's bills, and everyone should have up on their screen a slide that says provisions designed to increase schedule control. So Andrea's, the bill in Oregon has a pretty robust and developed right to request and receive schedule changes for employees in certain high priority categories, and provides for an interactive process for all employees to make scheduling requests and protections from retaliation for making those requests. And Andrea, I think it would be good to hear from you on why you decided to make this such a central piece of the legislation that you introduced.
Right, we wanted to give everyone the right to request and have there be an interactive process where the employee has some say and the employer has some say. But in some cases where there's a serious health condition of an employee, where the employee has caregiving responsibilities for a family member, if they have a second job, or if they're participating in a career-related educational or training program, that we felt like we needed to have a higher test, so that they actually had a right to receive that alternate schedule unless the employer had a bona fide business reason for denying that request in those conditions. And then I think the other thing to highlight from Oregon's law that's a little bit different than or Oregon's bill that's a little different than some of the other places is we actually gave the employee at all stages the right to consent. So they have to be asked and they have to consent to work an alternate schedule, after the schedule is published within 21 days, because we do feel like it's really important that employees have a say in accepting or denying a schedule change.
Thank you, Andrea. Another question that states have had to tackle is whether to make their bills applicable to all employees, to non-exempt employees, meaning to workers who would be entitled to overtime under the Fair Labor Standards Act, or to some subset of employees, such as employees in a particular industry, the service sector, et cetera. And while many states have taken the approach of making their bills apply universally to hourly workers, California took the approach of having a bill that applied only to workers in certain sectors. So I think, Jenya, it would be great to hear from you on the development in California deciding to make this a bill specific to employees in certain sectors and with an employer threshold size.
Oh, thanks. Yeah, I think that in California there's a very large focus on small businesses and the impact that these kinds of things have on small businesses. But a lot of the retail work, especially in California, people are really working for these larger businesses. That's where a lot of the workers are working, and that's also where the first push is coming from, where we're hearing from workers that work for pretty large retailers that would fall under this bill on the changes in their schedules. And the other thing too is that these large businesses, they often lead the way to changes in the small businesses. If something works for the larger businesses, it can really have a bigger kind of impact. Definitely, in terms of the opposition, that can kind of change the narrative around this really impacts small businesses. But the opposition to this has been pretty fierce because they were really ready for it once it happened in San Francisco. And Assemblymember Chu, when his election and went to Sacramento, he said they were already waiting for him, asking him if he was going to introduce a bill like this. So, I think the fact that it's very new is still making businesses come out against it as a job killer, or at least a business lobby. But I think, having the larger, having it, apply to the large businesses, it makes it very doable, and it impacts a really large number of workers who are right now organizing for these changes that are either members of UFCW or that UFCW is definitely pushing for better legislation for all retail workers in California.
And one of the most thrilling things about the scheduling campaigns that have lifted off the ground in states across the country has been the tremendous worker organizing and outpouring of support and, clear demonstration of the need for new labor standards in this area. Jenya, we have a question from someone on the call. Could you speak to the current status of your bill?
Yes, it passed out of its first committee, and we expect it to go to appropriations May 13th. So there's still a big push. There's a lot of support. Just like businesses pushing on one side, there's definitely a really diverse and great deal of support on, for all these different organizations, other legislators who signed on as co-sponsors, and for California, we're still making a push for more organizations to sign on in public support of the bill before the appropriations hearing in May 13th.
Thank you. And as for Oregon and Maryland's bills, Charlie, would you like to give a status update? And then Andrea, if you would do that. And Andrea, you have a question about the composition of the coalition in Oregon. So Charlie, would you give a status update on the Maryland bill?
Certainly. Our legislative session ended in April. We withdrew the bill this year without action because we knew that it was an education year. So we will be building our coalition over the summer and reintroducing the bill with stronger language and taking some of the lessons we learned from this first year and what we learned over the summer. We'll be reintroducing it again in January 2016.
Great, thank you, Charlie. And Andrea, could you did mention the work group that you anticipate will happen, and is that geared toward reintroduction?
Yes, that's right. We had the bills that we drafted. We had some additional scheduling bills that were drafted by legislative members, and the idea is during the interim between this session and next, we will have a work group with interested parties and legislators to sort of work through a number of different concepts and come to some consensus. And then as to the coalition, I would say, this is an introductory year. We're learning a lot about this issue and about the way it impacts different folks. We immediately had some different unions who were involved in the effort and other racial and gender justice groups who are really interested in following the progress of this issue, but we're a small and growing coalition as the issue sort of gets more prominent.
Great, thank you, Andrea. And we're just coming up here on the top of the hour. I want to offer to our presenters on the call if there's any final words that you would like to say about your plans for next year, or the importance of the issue, that we can do a lightning round on that. I've stumped you all.
Well, this is Charlie, and
what happened?
Charlie, it looks like you're on mute. Can you hit the mute button on your? There you go.
Oh, certainly. I was just going to say that how one of the valuable lessons we learned by broadening the coalition and the wake up that we had with legislators when we were able to talk about this in terms of the impact on children. That really seemed to be the thing, and using the flexibility argument against the employers. In this situation, employers really talked about their need for flexibility and a flexible workforce, when in many other circumstances, they will come in and argue about the importance of having predictability in policies that impact them. So we both used that argument against them and brought in the perspective of this was having a very real impact on children, and those two things seem to really break a logjam with some of the more recalcitrant legislators for us.
Thank you, Charlie. Any final words from other presenters before we wrap up here at the top of the hour?
This is Andrea, and I would just echo what Charlie said and add, I think child care providers and other folks who interact with or sort of feel the ripple effects of scheduling chaos in families' lives are natural partners and spokespeople for this issue.
Yeah, and this is Jenny. I also would echo that, and I think anything we do on this issue, getting out there with legislation, pushing for support, organizing it, is so important for the millions of workers around the country that have this problem, because we so often, with every work-family issue, we see it as a personal problem or something that we need to get it together and work on. And when we are out there with legislation and out there pushing and organizing and hearing people's stories, I think it really gives people a lot of hope that this is an issue that we all share together and it's something that we can actually work on and make progress on.
The personal is political. And on that note, I'd like to thank you, especially to our presenters and to everyone for participating in this call. What we are doing here together, conceptualizing a new set of labor standards to respond to the crisis in hours and income that so many workers are experiencing, is no easy task. It is an honor to work with all of you on achieving this goal and with so many of you on this call. Thank you for all that you do. Amanda, do you want to close us out?
Sure. Thanks, Liz. And I would just echo the thanks to everyone for joining us and to all of our presenters. As a reminder that we have recorded today's webinar, and we will circulate the link to the recording as well as to the webinar slides within the following days. So you're able to revisit it and also share it with anyone who may be also interested in this topic. And with that, I will end the webinar. Thank you, everyone.